Keeping Faith with the Constitution explores how many of the constitutional principles that we now consider fundamental have been forged through a dynamic process of interpretation in which social context is considered.
I want to say that this is an extraordinary moment for these two volumes to come out, because I suspect that sooner rather than later, this is a debate that's going to be happening on cable news and on radio and in the op-ed pages. And so I really want to thank ACS.
Now, to put these claims into a little bit of context, let me highlight three features of the Constitution that really anchor our book. The first is that the Constitution, as Franklin Roosevelt put it, is a layman's document and not a lawyer's contract. In other words, it's a document that belongs to ordinary citizens and their representatives every bit as much as it belongs to lawyers and judges. A second key feature of our Constitution is that its framers repeatedly chose general language to establish basic principles with broader applicability than the specific problems that gave rise to particular provisions. Third, our Constitution is not merely an aspirational document or a statement of abstract principle. It's a practical framework for constituting a system of government and operationalizing our commitment to democracy, liberty, and equality.
You can't go around wearing a rubber band on your wrist that says WWJMD for what would James Madison do, or WWJBD for what would Jonathan Bingham do. You have to ask, what do their words authorize Congress and the people to do today?
And we hope that the writings here will show that there is a response to originalism, that there are arguments out there, that there are other methods of constitutional interpretation that do have intellectual integrity, that are intellectually rigorous, that do channel judges' discretion in appropriate ways. And that these methods are not only intellectually sound and workable and consistent with the role of an unelected judge in a democracy, because that's all a little bit defensive, but that they also have something affirmative to offer, a fuller and more robust understanding of the Constitution. Nobody in our volume is arguing that text and history are irrelevant. Far from it. I think all of our authors would agree that text and the historical context behind it are very important starting points in constitutional interpretation, that they are valuable sources of constitutional meaning.
And gee, what timing, you guys. I mean, wow. Now, tell the truth. Was this really just a coincidence? And I do believe that the volume that our distinguished authors here have published now is going to make a very important contribution to that debate. It's very carefully researched and reasoned, very measured. It's among the best defenses of a non-originalist interpretive methodology that I have ever seen, but it's my sad responsibility nonetheless to say that the challenge it makes to originalism, I believe, fails. To me, originalism is what democracy was to Churchill. It's the worst method of constitutional interpretation, except all the others. And I want to begin with some fundamental, what I consider anyway, to be fundamental postulates. The central premise of our constitutional order, the basis on which the whole American fabric was erected, as Marshall put it in Marbury, is that the Constitution embodies the supreme will of the people and is accordingly a superior paramount law, unchangeable by ordinary means. I believe that all non-originalist theories are ultimately designed to spare the judge that pain, to free the judge of the original meaning of the Constitution and of a obligation to search as carefully and as objectively and as honestly as the judge can for that rule of law.
I want to say just a small point about the feeling the pain point, which is just to say that certainly that criticism shouldn't be unilaterally directed at justices like Warren and Brennan. I don't know how much pain Justice Scalia feels in his own applications of originalism, especially when he decides that it doesn't apply.
One of the justices that Chuck didn't mention, perhaps because he was very explicit about the extent to which he felt the pain of what the Constitution did, is the justice for whom I clerked, Harry Blackmun, who several times wrote in opinions, look, if I were a legislature, I would not do this. He said that about some of the criminal sentencing, and I think that would be true if you looked at liberal judges today who take a view that the Commerce Clause power of Congress is quite broad, and therefore they will enforce what they consider to be savagely stupid drug laws and criminal penalties, because that's what the Constitution gives the Congress the right to do.
Because I think of Chief Justice Warren's work mostly in the criminal procedure area. And I think of some of his biggest decisions like Miranda and Terry. There's pain all over those pages.
And what we saw at the Supreme Court 2 days ago in the oral argument in the Muddo case is a bunch of the justices saying, well, we think the Civil War is over. We don't see any reason to treat southern states as if they got it wrong. Or like, well, that might be an appropriate position to take, but you cannot take that as a matter of the original public meaning of the 14th Amendment, because the original public meaning of the 14th Amendment was Congress would have the right to guarantee racial equality in the United States. And the people who promulgated that amendment gave Congress that right in part because they did not trust the court to understand what racial justice meant. And so if we're going to be originalists and original public meaning people, that's an area where I think that the conservative members of the Supreme Court should back down. If we look at the D.C. Guns case from last year, which is the D.C. Guns case, both sides talked about what the original public meaning of the amendment was. But let me just read you a little tiny passage from Justice Scalia's discussion of what the word arms means in the Constitution, right? Because the Second Amendment says it's the right to keep and bear arms. And he says, some have made the argument bordering on the frivolous that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communication, and here he cites a case about the internet, and the Fourth Amendment applies to modern forms of search, and here he talks about thermal imaging devices. The Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Now, why is that? Because he understands that the word arms stands for a principle about the right to self-defense.
The principles of the Constitution were indeed designed to endure, to be immortal. And to be applied to new circumstances and things that the founding generation didn't and couldn't possibly have foreseen.
Part of our point in the book is just everybody uses a method that looks at all of these issues. And so we should stop arguing as if the method is going to determine the result, rather than how people balance in individual cases the various forms of understanding the Constitution, its text, its structure, the history, the shared understanding, and the way that the Constitution has developed over time. We're not doing anything different in that sense than they are. We're just doing it better.
The term strict construction actually can be found all the way back to Gibbons and Ogden in the early 1800s. In which Chief Justice Marshall is writing an opinion about the Commerce Clause, and there's a passage in there in which he says, gentlemen, meaning counsel, contend for a strict construction of the term commerce, and he rejects that. And he says that that's not the nature of a constitution, is that the Constitution was meant to be an adaptable instrument for times to come.
Part of the importance of the book is it's not written primarily for judges. This is not a handbook for judges about how to decide particular cases. Rather, it's an opportunity for us to talk to citizens and to legislators as well about how do they think about their constitutional responsibilities.
I want to thank ACS for inviting all of us, thank the panelists for their exceptional work today, and to thank all of you for coming.